Perhaps the most protected asset in the entire country is a Florida homestead. If you didn't know, Florida has one of the best, if not the best, primary residence laws in the country. Some people's sole motivation for moving to Florida from another state is to protect their hard-earned money from the collection of a creditor. The statistics say that nearly 1,000 people are moving to the state of Florida every day. That's about 345,000 people a year, which is nearly the entire population of Collier County. So what's bringing them here? Warm weather, of course, our beaches, and our tax benefits. Asset protection starts immediately from the moment that you declare your property your permanent residence. You're not required to apply or file anywhere. If you forget to apply for homestead, you are still protected. So what exactly is protected? Asset protection is liberally construed in favor of the homeowner. This is a big deal. Welcome back to another video. My name is Alysia Shivers. I'm your go-to Naples, Florida real estate agent. I've been servicing the areas of Naples, Bonita Springs, and Estero for the last 12 years, and I'd love to help you find your place here in Naples. Whether you're looking to buy property now, 6 months from now, a year, or even later, I'd love to help you start your exploration process. All of my information is below. Feel free to reach out, call, text, email. And if you want to be in the loop on what's happening in the Naples market, subscribe to my channel and you'll be the first to know. Here's what you need to understand. A homestead is protected from outside creditors if it's located on up to half an acre of property within a municipality, or if it's located on up to 160 continuous acres outside of a municipality. The key here is the amount of land that the homestead is located on. The value is unlimited and the square footage is unlimited. What a homestead is not protected from is unpaid real estate taxes or debt for which the homeowner voluntarily pledges the property as collateral. For example, a mortgage, a HELOC, or a private pledge for a debt. A homestead is also not protected from condo or homeowners association liens or mechanic liens arising from a statute, such as a contractor's lien. And it is also not protected from federal tax liens because federal law preempts state law. So you may be asking what type of property qualifies for a homestead. Well, those properties include a single-family home, a condo, including everything from a townhouse to a villa to a coach home, a co-op, and a mobile or manufactured home when you own the land. Just how much is the deduction? The short answer is it's $50,000 off of your assessed value, which is determined by the property appraiser. But the longer answer is that $50,000 is broken down as follows. The first $25,000 of your assessed property's value is exempt from all taxes. The second $25,000 is fully taxed. And the third $25,000 is exempt from all taxes except school district taxes. The reality, though, is that very few, if any, improved residential properties here in Naples and Southwest Florida is valued at less than $75,000. So the breakdown is really not all that critical. So you may be wondering, how do you qualify? The owner of the home must be a natural person with legal or beneficial title, meaning that title is either in an individual's name, or it's in a standard revocable trust, or it's in a Florida land trust to qualify. You cannot homestead a property that's in an LLC or a corporation. You must apply for homestead by filing a form with the property appraiser by March 1st. And the intent of that property that you own here in Florida is that it must be the owner's permanent residence, or the permanent residence of someone who is naturally or legally dependent on that owner. So what does permanent residence actually mean? It means it's the place where the person has their fixed and their principal establishment, and that whenever they are absent, they have the intent to return. The key is you have to have the intent to return. One of the most commonly misunderstood requirements of a homestead is that no minimum number of days stay is required. You may have heard, oh, you have to stay 6 months and a day in order to qualify for homestead. That's not true. Believe it or not, there's not even a one-night minimum stay required. The key, again, is that it must be the owner's intent to return when absent. Another qualification for homestead is only one homestead per family unit. Neither the owner or his or her spouse or his or her domestic partner can have another homestead in the state of Florida or any other state. Even two unmarried people cohabitating together are considered one family unit. U.S. citizenship is not required, but proof of permanent U.S. legal residence by the owner or his or her dependents is. Undocumented immigrants are not entitled to the homestead exemption, nor are people with student work visas or tourist visas. They can purchase property in Florida, yes, but they cannot homestead. So what proof do you need to provide? You will need an affidavit stating that neither you nor your spouse or your domestic partner have homestead benefit anywhere else. You'll also need your social security number, and you'll need your driver's license with the property as the address. And you'll need at least one car registered to that property address. You'll need your voter registration at the property address, or you will need a declaration of domicile. A declaration of domicile is required for non-voters, not for voters. Some people file the declaration of domicile anyway as additional proof, just because some of the states demand proof that they are now bona fide Florida residents. So what about if you want to rent your homestead property? You can rent your property, just so long as it's after January 1st of any given year. And the homestead property cannot be rented for more than 30 days per calendar year for 2 consecutive years. So the bottom line is this: don't ever rent your homestead property on January 1st of any year. You can rent it out for 30 days or fewer after January 1st in any calendar year. And those 30 days do not have to be consecutive. And you can rent up to 6 months after January 1st every other year. But really the best practice is not to rent the property at all. If you live in your homestead property but you rent out a portion of the home or rent out individual rooms, say for instance, you live on the second floor and you have tenants that live on the first floor, you could potentially lose a portion of your homestead benefit. It is at the discretion of the property appraiser. Having a home office within your homestead property is totally fine. That does not result in a loss of your homestead benefit. In addition to the homestead benefit, there are additional benefits to qualified individuals. Those include seniors over 65 with a limited income, veterans and first responders who are disabled, surviving spouses of veterans and first responders who died in the line of duty, and widowed or blind persons. You may have also heard about the Save Our Homes benefit. In 1994, Florida voters approved this benefit. So what is it and how does it work? Florida's real estate market has long been characterized by booms and busts. But historically, the appreciation created in the booms has heavily outweighed the declines in any of the busts. As a result, many Florida homeowners, especially the elderly who purchased their home many years ago at a much lower price point than the home's current value, were facing ever-increasing tax bills. The Save Our Homes benefit basically says that the assessed value of a homestead property cannot increase more than 3% per year, or the Consumer Price Index, whichever is lower. Over the years, the Save Our Homes benefit can become a big accumulated benefit because the assessed value stays artificially low. This artificially low assessed value is called the cap assessed value. Okay, so the Save Our Homes benefit benefits those who want to stay in their homes longer. But what about those who want to move? In the past, a homeowner would lose their accumulated benefit when they sold their old homestead and bought a new one. And that's because all property in Florida is reassessed when it is sold. To remedy this, Florida voters in 2008 approved portability. Portability allows a homeowner to transfer their accumulated Save Our Homes benefit from an old homestead to a new homestead. There are some rules, of course. Both the old and the new homesteads need to be located within the state of Florida. They can be in different Florida counties, but they cannot be in another state. You must establish the new homestead within 3 years of January 1st of when you abandoned the old homestead. So for instance, if you sold your old homestead, say in March of 2020, you must reestablish your new homestead by January 1st, 2023, because the 3-year timeline starts as of January 1st of 2020, which is the year that you sold your old homestead. You must apply for portability. It is not automatic. To take advantage of portability, you can simply sell the old homestead and establish a new one. Or you can move out of the old homestead, buy a new one, establish homestead there, and then rent out the old one. You can port your full homestead if you are upsizing, or you can port a percentage of it if you are downsizing. $500,000 is the maximum amount that you can port. This video was just to give you some insight into asset protection here in Florida, the homestead benefit, save our homes, and portability. There is no doubt that our tax benefits here in the state of Florida are a reason why a lot of people are moving here, in addition to our warm weather and our beaches, of course. Will you be joining them? We'd love to have you.